So this training session we're going to do is going to be on basic knowledge of Help to Buy and more importantly on new builds. So reverse that, new builds and Help to Buy. Okay. Now I know a lot of you have a lot of issues with this. Remember that Peter and myself are always here to help. So if you have any specific questions, then please come and talk to us, and we'll be happy to go through it with you. Okay. So going first of all through the new builds, like any file, everything starts the same. Okay. So importantly, know your client, do your AML check, do your source of funds, and use a checklist. Now, as I said in a previous training session, these are very obvious things, but they must be, they must be done at the beginning of the file. Okay, if you're acting for a company, you get a company resolution, you find out who your directors are. Okay, make sure you've done your source of funds nice and early. If it's Help to Buy, how are they dealing with the rest of the money? If it's money coming from a gift, these things you need to know early on. If the money's coming from a gift or the money's coming from a loan, it will not be acceptable to Help to Buy. We have to know these things immediately. They have to let the Help to Buy, and they have to let the CML disclosure form, they have to understand when or how the monies are being accumulated. So it's more important in this case. So know your client, do your source of funds, and your AML checks very early. And use a checklist. Now a checklist on this will help you. Everyone gets very panicky when it becomes a new build. But a new build is simply the same as any transaction, except for there's just more paperwork, which means you have to be more organized. The checklist will help you become more organized. That's all it is. It's more paperwork. Okay? So using a checklist will help you become more organized. So going into it, usually if you're acting or purchasing from a large development and you're dealing with one of the larger law firms, normally what you will find is you'll have a code and you'll go to a central system and you'll download various documentations and you'll download a pack. So you need to know that earlier on and have a look at it. Okay? In the pack, we will always usually consist of the contract, their title, an information sheet, a lease or a transfer draft, depending if you're purchasing a flat or a freehold, planning documentation, building regulations, and some miscellaneous documents like the warranty, the postcode information, any service charge information, building regs, and rights of light if necessary. So what we're going to do here is we're going to build a picture. So when you download the information, it'll be usually a lot of documentation. It's the same as you do with any other transaction, which is just build a picture and you use your checklist. So we've identified our clients, we have checked their source of funds, and done the anti-money laundering checks. Very important, very simple, we've done those. Right, now we're building a picture. So what I would do is I would download the contract and I would download the title. And like any contract, like any title, I would then take the lease or the transfer that's going to go to my client and check that they can sell the property. So you check on your lease and you check on your transfer. If it's a freehold, it'll be usually a transfer of part. You check and make sure that they can sell the property. By how you do it, you check the title, you check the proprietorship register, and you have a look at it. And you check the contract, and you make sure the parties are the same as those on the lease and on the title. Okay? If there's any management companies to be involved, you have to check on the lease if it's in the case, if they're going to be on the lease as well. I've had previously where I've acted transactions where sometimes one party can own the land and a developer is developing it. Now you just have to make sure in those cases again, it's very simple. The person whose name, the proprietor of the land, they're the ones who have to be on the lease and the transfer. Maybe the developer is included in the contract, okay, but the person who's transferring the property to you or granting a lease, they have to be on the contract as well. It's very simple. That's how you do it. You just have to check it and be simple like that and build yourself a picture. Okay? Another vital document which you'll download is the information sheet. I like to read that nice and early. That will give you all the information that you should need about the property. It will often go through the contract. It will often through the title, and it will give you, if there's any restrictions on the title or any entries, it will say where they come from, it will say what they relate to. And the idea being is the information sheet from a good developer, and the majority of the large developments where you deal with these and their help to buys will be a large developer. The idea being is that the information sheet will answer most of the points that you have there. And they give that to you because often there's a deadline in order to exchange of 28 days. So the idea being is they'll give you as much information as possible. So read the information sheet, read your contract, you read your title, and you lease and you transfer. And like I say, you build a picture. So I've checked, first of all, that whoever it is can sell the property and grant to my clients, as I would do with a normal title. Okay? And like I've said, you have to just think of some extra points. And the way I think of it is, right, I've checked that they can grant it, now can my client get there? Can my client get to the property they're going to? Is there an estate road? And you have to check this by, you have a look at if they provide you with a search with the nearest searches, you do a map search, and you say, right, can my client go from the main road to his flat or to his house? Does he need to have an estate road? If so, you need rights of way. Okay, and the rights of way have to be vehicles, and you have a look at that. I've now checked that my client can get to where he needs to go. I can check that whether my client can go into the building. Can he get into the building and get up the stairs and into his flats? That's, again, you need rights of way there. Now, they will either be in the transfer or the lease, and you just, as I say, you build a picture to check that your client can do that. Okay. Once I've checked it, once I've checked if my client can get to where he's going, I've also seen, does he need any other rights? Now, if he's buying a flat, he needs rights of support. He needs rights to go into neighbour's building. He needs rights to go into, to maintain his property. And he may have rights to have common areas. These are all standard rights which we should all be familiar with. And I check to make sure, are these required? If he's buying a freehold building and he's buying a property, does he need to go next door? Does he need to go next door to maintain his property at all? Okay? Does he need to do any of these things? These are all things which I check to make sure if the client needs it. Okay? Once we've checked the rights, we then check the covenants. Okay? To have a look what's restricting my client, so I can advise them of it. Okay? But really, it's a case of, I like to make sure, from my own point of view, that my client can buy what he wants to buy, he can get there, and he has a right to enjoy it, and he can use it. The rest of it is largely in favour of, largely in favour of the freeholder, okay, or the other party transferring it, okay. So the reservations, for example, well, look, the reservations in favour of the freeholder, so he wants to make sure they're correct. We advise our clients of it. The restrictive covenants, they restrict my client's use. That would be the tenant's covenants. We just check through the lease. And then we have to make sure whether or not how they restrict the clients, and the client is fully advised on those. Okay? What I also then check with a leasehold or a transfer is what we have at the moment is the big issues, which is ground rents and rent charges. So, Obviously with ground rents, I have a look at those. If my client's buying a lease, I have a look at it and I check the CMO handbook and I make sure that they're compliant. Remember, in London, as at today's date, in London it is £1,000. Outside of London, it's £250, and this is for the life of the term. We try to make sure that there are minimum, I would say, at least 10 years, and the ideal is RPI index linked. Check these, and if they are not favourable, you have to notify your client and possibly the lender. Okay. Remember, with rent charges, if your client's buying a freehold and it's a freehold estate, there will likely be an estate charge there. Check how is it protected by a rent charge? If it's protected by a rent charge, you have to advise your client. Remember, if it's a rent charge and your client does not pay the rent charge fee, then the freeholder could possibly make it into a leasehold interest. Also, just be aware of the CMO handbook. The information I'm giving to you is the CMO handbook as at today's date. This always changes. I mean, I sign up to InfoTrack, sign up to the email CMO handbook. Be aware of the changes so we can be identified, so we can be notified of them. For example, I believe it's Nationwide has a requirement at the moment that 125-year leases at the start are unacceptable. Okay, so just be careful of the CML handbook. Okay, so we've now checked our contract, we've checked our title, we've checked our information sheet. These are very, very basic things which you would, generally speaking, would do with all transactions. You would check your title, that's what you would do. You were buying an established freehold. You would check the covenants, you would check the lease, you would check these things. There's nothing really different here. The only difference is that you're making sure that the correct entries are there at the start. Okay? And you're just making sure that everything is in order. And if you think about the way I do it, for me, what works for me, is I like to think, as I say, very basically, I'm buying a flat, I want to get to my flat, can I enjoy my flat, can I use it for what I want to use it for? Now, that's the way I think about it. Okay? That works for me, I'm not sure about yourselves. Where you've got to go now a step further and is with planning and building regs, and obviously the service charge information. Now, planning will detail how something will look. Okay, you've got to check the planning permissions, and you've got to make sure they've all been signed off. That's what people don't realise they've got to do. They've got to check the planning permissions, have a look at them, make sure that they are there, and make sure that the planning permissions have all been complied with. There will be a number of conditions with the planning. So you check the plannings and you make sure that they've all been complied with. You'll probably have a Section 106 agreement. That's an agreement that's made with the local authority that will likely ask your developer to do something in order for the planning to be granted. This could be, for example, building a fence. It could be, for example, making a payment. These things you want to check, and you want to check that they've been complied with also. There may be a community infrastructure levy, a SIL payment. You want to check if that's payable, has that been paid? The requirements for the Section 106 and the requirements for the SIL will go to your client if they have not been complied with. Okay, so you have to check that the planning conditions have been complied with, any Section 106 agreements have been complied with, and that any community infrastructure levy charges, if they apply, they've been complied with as also. Okay. Now, if it is a listed building, that's a whole other issue, and you'll need listed building consent. With listed buildings, they're the only ones where they are always enforceable by the local authority. And if you have one where there's a listed building, I suggest you speak to myself or Peter, or someone more senior, and we're happy to go. I'm sure that we're happy to go through it with you. But with a listed building, you will also need listed building consent. Very important you get that, and you have to check what part of the building is listed. Is it the entire building? Is it the facade, etc.? Okay, but that is something you need to have a look through. Okay. Rights of light is something which people are not very familiar with. there should be a rights of light survey report undertaken by the developer. This will explain whether the proposed building will breach any rights of light. Now, quite often, if we're developing in London, someone suddenly puts a big building up, they will do a rights of light survey report. That report will let us know whether or not there are any breaches of rights of light. And that will tell you what suggested procedures take place. Quite often, it will just be an indemnity insurance policy. But you want to have a look at it and you want to check it. Okay? Check, and also check the miscellaneous documents, the service charge, and the postcode. Okay? Now, also being a new build, you will likely come across a warranty scheme. So it will give you information about a warranty scheme, NHBC, which is usually the largest, there's Zurich, I think there's Build Zone, and there's a few others as well. You will need to check the CML handbook to make sure that they are compliant. Now, usually, when I mean NHBC, lenders accept NHBC, but if you're dealing with a small developer, I know NHBC are quite, they want a lot of information, and sometimes they can be expensive, and they don't like using them. So if you might want to check to see which warranty provider is being put in place. You will have to often get a link, and you'll have to sign in. Okay, so see how you get the warranty and how your client benefits from it. That's with the warranty, it's a 10-year warranty. I would suggest that you also read the warranty because people often think that with a 10-year warranty, if it goes wrong in 10 years, it doesn't, they're fully covered, they get their money back. It doesn't work like that. Yes, I think it's for the first year or so, but then the warranty almost goes down in value almost as the years go on. Okay, so we should notify a client how it does that. Okay. Going back to the contract. Now, a contract for a new build will usually have certain clauses in there which people need to be aware of. Okay. One of them in there was that it will likely say that the building completion will be on notice, so people need to be aware of that. So once they exchange contracts, there's no fixed completion date. If they're buying with a help to buy, I'll come to that. If they're not buying with a help to buy, you have to always advise them it's your responsibility once you exchange contracts that you've got enough money. If your mortgage offer expires, that's up to you. Okay? There should usually be a long stop date on there as well, because if there's not a long stop date, then you've got to put one on. Do not tie your client in indefinitely. Check how the deposit is held. Very important, you check how your deposit is held, and you check and tell your client how the deposit is held. Most developers, it will be held as agent for the developer, which means it can be released to the developer. The developer will quite often take the deposits and use it to fund a build or use it to fund for cash flow purposes. Client needs to be advised that if the developer does go bust, which, let's be honest, in today's climate is not unheard of, that they could lose their deposit. That's why off-plan is often cheaper. So they have to be aware of, we're going to give a deposit, there's no guarantee that you will get that back. You will be an unsecured creditor if the developer goes bust. Also, they will say in there that if there's a show home or if they show the building to you, the developer will often put a right in there that the property we can use, it can be a similar size or similar materials. It may not be exact, and again, let your clients know. And they'll often have a formula in there, a percentage of how much bigger or how much smaller it can be. Okay, but it's good, again, let people know and let them know about whatever money they've got to spend. I mean, I've had clients complain to me about an engrossment fee. Oh, it's not found paying this. Most developers, solicitors now will charge an engrossment fee or a stupid fee or whatever they want to charge. Turn around and let your client know about that. Okay, when it comes to completion, confirm how completion is going to be. Completion will often be on the service of a notice, Once the warranty provider has confirmed that the property is complete, so it will be watertight. So once they confirm it's complete, it's built, the roof is there, it's okay, and they've signed it off, they'll serve a notice and you'll then have 2 weeks to complete. That's often the case. So check with that. If it is a developer with, I believe it's around 4 or less buildings and a warranty scheme is not required, then a professional certificate by an architect will be required to sign off the property. You have to get it signed off. You have to have the sign off document. So tip, if you're acting for developers, sometimes you have to make sure they get it signed off by some sort of professional certificate. If you're not the warranty scheme, then by an architect. So there's a standard form that needs to be used. Also check the CML disclosure form. That's very important. You check that also as well. And if there's any disclosures or anything, then you have to report it to your lender. Jumping a little bit into commercial now, what people are not realising is commercial property recently changed with the use class system, and it went from A1, A2 and A3 and we now have a use class E. So if you were previously granted an A1 or an A2, you'd use class E. Where this will be important for yourselves is you may have a building, quite often these properties are built where it'll be commercial at the bottom, and you may have a property where it's residential at the top. They may have had permission for an office downstairs, use class of A1 for a shop, which is all fine. But that now means that they will be use class E. By being use class E, in theory, you could eventually get a restaurant in there. Now, you should let your clients know. I'm not sure how this is going to develop because some lenders don't like restaurants on the bottom or properties above restaurants. Some clients don't like it, and you could find in the future, I wouldn't be surprised if we're blamed in the future for a property being devalued because all of a sudden a restaurant is in there. It doesn't mean the freeholder will absolutely grant it, but again, where there's a lot of empty commercial property spaces, and I'm sure landlords will let us fill. If someone with a restaurant comes along and says, look, I'll pay you the rent you require, then you wouldn't blame the landlord for agreeing to it. That would then devalue the leasehold property. So check the planning permissions. If it was A1, A2 or B or D, then it will now be a use class E, and you should advise your client there is a risk that a restaurant will could go in there. Some may be bothered. If they're not, then wonderful, but at least you've covered yourself. Now, going to Help to Buy. Help to Buy is simply a step-by-step procedure. If a developer wants to use Help to Buy, the way it works is that the Help to Buy scheme is a government scheme where if a property is being sold for 400,000, the government may contribute 200,000, and then the purchaser will have to fund the 200,000 themselves. So they may turn around and get a £20,000 deposit, £180,000 mortgage from a bank, and the government will fund the £200,000. The money does not go to us as solicitors, the money goes straight to the lender. Developers like it because it means that they can put the price as high as they like. Because the way the general public look at it is that they are saying, well, they're paying 200,000 for a property. Property may not be worth 400,000, or if someone was to go along with cash, or with a mortgage to buy it, they may be able to negotiate the price down to 380, 370. By using the Help to Buy scheme, it allows the developer to maximise the value of that property. So they quite like it, and that's the way it works. But it is simply a procedure that you need to have to follow. If they're going to use the Help to Buy scheme, they have to have certain provisions in the contract. These are there to protect the client. And generally what they are is that if a client, the contract is conditional upon your client having a qualifying or acceptable mortgage, and if they lose that mortgage, the client can withdraw and get their money back. Okay, so it's good to point these things out. The way the procedure works is you have to have an authority in order to proceed. You check the authority to proceed, it will have the information in there. It will break down what the disclosure, any incentives, and you have to have the CML disclosure form. It will turn around and show you what the contribution is from Help to Buy. It will tell you what should be funded from the mortgage company and what's going to be funded from your client. You have to check that with all the information you have and with your client. It's vital that you check all these things. Okay? Once you have your authority to proceed, you then have to get authority in order to exchange. The Help to Buy won't give you an authority to exchange unless you give a Form 1, which is an undertaking. And this is a form where you confirm that you've checked everything, and quite often you will have to give with that, you may have to give a mortgage offer, but you certainly have to give a valuation report, and may have to also give a disclosure form. Some of you may know we recently had an issue where the Form 1 wasn't correct, and the valuation, although the client had a mortgage offer, the valuation was £30,000 less. We submitted the Form 1. We didn't get authority from Help to Buy. We said that the valuation was the same as the purchase price, which obviously was incorrect, and Help to Buy then gave us the authority. Even though Help to Buy had the valuation report themselves, they missed it. It doesn't matter, we were still held to blame, and we had to run around and try and get it fixed. It was a little bit of a perfect storm in that we couldn't rely on the provision to protect the client, as the solicitors were trying to argue, well, no. They had a qualifying mortgage, which they did have a qualifying mortgage, and the issue was because of something that we had submitted. Now, it didn't get tested, but it's not a nice situation to be in. You just have to read everything carefully. It goes back to what I've said previously, you read everything. So you just check carefully, simply. Check my mortgage offer, check the valuation report. If you haven't got a valuation report, you ask for a valuation report. Certain things have to be crossed out with the Form 1. Just read through it. Make sure if it's accurate. Okay? You check that. So then once you've done the Form 1, you get authority in order to exchange. That says you have to exchange within 4 weeks. Okay? Once you exchange contracts, you then have to give confirmation to Help to Buy, and then you have to submit what's called a Form 2. So you give them confirmation of exchange, and then once the developer serves you with a notice saying, right, we're now going to complete on this day, you then submit a Form 2, which will then which will give the confirmation to the developer, which you then give to the developer to confirm they're going to get their monies and allow you to complete. Okay, that's the process. During that process, you have to get a mortgage signed by your client, and it will be a second charge on the property. So, the way it works is with Help to Buy, you have your normal mortgage, they have a first charge. Government is topping up with a second mortgage, that will be protected by a second charge. Land Registry will deal with that. Your mortgage should refer that it's a Help to Buy mortgage, just check special conditions. If they do, it will automatically, your lender will be a first charge, and the equity mortgage will be a second charge. Make sure you have everything signed, executed before completion. Ensure that everything is there. Use your checklist. Make sure you're ticking off that checklist. Do not allow yourself to complete without the signed documentation. You are giving undertakings to Help to Buy, undertakings which you could be found in breach of. So, to recap with Help to Buy, I get my authority to proceed. I read through that. I check the information in there. I check the CML disclosure form, I check the mortgage offer, and I check the valuation report. Once I've got the authority to proceed and I'm ready to exchange, I give the Form 1. I then have 4 weeks in order to exchange. Give Help to Buy time to do this. They need a few days. Don't give the form and expect to be happen straight away. You'll be disappointed. You'll have angry clients. So, you have given your authority to proceed, you have your Form 1, and then you get your authority from Help to Buy to exchange. I can now exchange with Help to Buy. Wonderful. I personally will try and arrange to get documents signed by my clients before I exchange. Okay? Try and get your mortgage deed and everything else signed by your clients before you exchange. Then, once you've got the authority to exchange, you then give the confirmation of exchange to Help to Buy. And when you get served with a notice, or when just before you're ready to complete, when you get served with a notice, you give the Form 2, which is the certificate of title to Help to Buy, as well as certificate of title to your other qualifying lender to get the confirmation to the developer. So you've just got 2 mortgages running at the same time. That's all it is. And with Help to Buy, you want to give them, again, don't give the confirmation to the developer, don't give the Form 2, the certificate of title, with 2 days ready to complete. You'll be disappointed. Okay? Make sure you give yourself enough time. All right? And then send it off to registration, and you just have to keep them updated. And that is that. Thank you.